Good morning, everybody. It's half past ridiculous, and we're seeking a Sentimendium. As always, this is going to be an interesting show today because we really have no idea where we're going with this. We don't even really have a plan for today, so we're just going to wing it. And we got a bunch of people in chat. Hopefully, they'll have some questions that'll be so helpful. We're thinking about talking about tools. What tools do we have? What can we use? What options do we have when we wind up getting stuck in a system? We're a little reluctant to step into that in any sort of a big way because that could be considered advice. And although that is what we're doing, we're not supposed to. Could get us into trouble, but that's okay. And if you don't know how to deal with it, there's lots and lots of people out there that'll grab onto something like this and try to run with it without having the requisite knowledge. And we really have to stress that this is chess at 80 miles an hour. And if you don't know the moves, if you don't know what the players on the board can do and how they can change what they can do over time, you're going to have a really, really difficult time with this. And this came up with the stuff that Heather's doing with the global collateral accounts, with the treasury accounts. People jump into that without knowing the ins and outs and all the details. And that will inevitably get you into a lot of trouble. Whether the trouble is justified is irrelevant. Most of the time, it's not justified. They're doing it. You're going to get into trouble not because you did something wrong, knowingly wrong. Not that you're trying to cause an issue or intend to cause a problem, but if you don't have all your if your T's aren't dotted and your I's aren't crossed, they're going to find something that they can use against you, and they will stuff it down your throat so fast it'll make your head spin. So please, if you are going to implement any of this stuff in any sort of a significant way, make sure you do your research. You can't do this with a month's worth of knowledge. It won't work. I shouldn't really generalize that way, because there are people there who may have high-level mentors who can help them through these processes. But for most people, you're looking at a long, long time of research and thinking and pondering and meditating on the issues and looking at all of the different scenarios and what can happen and what can go right and what can go wrong, so that you have the toolkit, you have the background to be able to stand up for yourself when you need to. And unfortunately, that's just the way it is. We're not quite to the point yet where you can just simply say, no, I don't consent, and that works. That's only one little bit of it. It's it's an important part, but it's not enough. You need to be able to hold these people to it. And the easiest way I've found is you just ask the right questions. Now, anybody who's looked at any of these situations, from licensing to registration to bylaws, they're very complex. They're very convoluted. They're very complicated. And getting the right questions is not an easy thing to do. There are a few that are very simple. There are a couple of I'm going to call them paint by number processes, which do have the effect of really throwing a wrench in the works. And sometimes they end it right there. Sometimes they just cause more problems, depending upon the energy you bring into the situation. If you walk into one of these situations and you're timid and you're not sure of yourself, you're going to get smacked. They'll pick up right on it right away, and you'll wind up eating it. But if you walk in confident and act honorably as an adult, and I'm not, we bring this up a couple of times, and it's not intended to insult anybody. It's intended to get people to think about how they react to situations, how they react to stimulus. And The I can't come up with the words to not sound insulting, so I'm just going to use the words anyway. Please understand, I'm not trying to insult anybody. If you walk into a situation with the demonstrated immaturity of not responding to the questions, you're reacting instead, or with the what we see in the kids where they stomp their feet, you're not the boss of me, and you get all mad and scream and yell and stomp your feet, that doesn't fly. You need to be very, very calm, be very deliberate in your answers and deliberate in your questions, and very confident. You can see this with tradespeople. One example that I'm really familiar with, when an apprentice walks into a complex trade, he's very unsure of himself, and he's very slow, and he makes silly little mistakes. When the tradesman walks in, someone who has a tremendous amount of experience with that, and they're very confident at what they're doing, there's a very definite change in the energy that goes into whatever they're doing. And this is what I'm talking about when I'm talking about entering this as an adult. You need that background. You need that experience, whether it's experience gained by role playing. Role playing is a great way to go about doing this, especially in a group. If you're sitting around with a group discussing this, when you're dealing with specific situations, because it helps you think about all of the possible scenarios that can arise. And okay, to go back to one of the cookie cutter tools, if you do wind up finding yourself in a court and it's a ridiculous statutory charge, you've actually done nothing wrong, there's no harm, loss, or damage involved, it's simply the state is billing you some money for something that they believe is a wrong. There's 3 questions you can ask the judge, and these have shown pretty good promise, but you got to be confident. You have to be in control when you ask them. The first one is, am I entitled to a fair hearing? And of course, the judge has to say yes. The second question is, if a conflict of interest takes place, or if conflict of interest is present, can a fair hearing take place? And certainly the answer to that is no. The third question is, who do you represent? Because the judge is representing your accuser. You have no neutral third party as an advocate, or not necessarily an advocate, but as an adjudicator in this situation. It partly exposes the fact that he's not a judge. He's an administrator. He works for the people who want the money, and he's not going to let go of his ability to take the money from you unless you give him no other choice. So the best tool you can have is the tool that paints them into a corner, forces them to answer questions they do not want to answer. That's from all of the research I've done, from all the experience that I've seen and the stories that I've heard, that is the best tool you can have. How that plays out is entirely situational dependent. So, Carl, you may have a little better or another point of view on this, because you've seen it from the other side.
No, I agree with that one, to be honest, and only because I've kind of done a little bit of research too. I know you mentioned that the World Freeman Society was probably the initiator of that kind of line of questioning. I know there are a couple of different things that or ways you can go. One is simply when they are in court, and this one's been successful too, by anybody prosecuted, or typically the judge, talking to you. You can be you don't pay any attention. You don't look at the judge. You don't look at the prosecutor. You can be looking down at a notepad in front of you, and they could be talking and saying, Mr. Smith, Mr. Smith, and asking whatever question they might want to ask is, what's your date of birth? And you can ignore them until eventually you get to a point and you turn around and say, are you addressing me? And this was an actual question that came out during trials, let's say, within Ireland. And it was suggested by somebody who'd been in the legal business for quite some time, now retired and pretty frail and old. But it works because the judge isn't addressing you, the man, he's addressing the person, the fiction. So that question can have some devastating effects too. I know if you want to research this a little bit more, there's somebody who's kind of gone running with it, and that's Mark Stevens of the No State Project, based out in the US. He has expanded that line of questioning to show that there is no such thing as a state, or you could expand that to a province in Canada. But if you want to kind of go along that and research that a lot more, and there's been a lot more success from people that have been trying that in court, and he does have the success stories on his website, which, if I remember correctly, is markstevens.net, and it's M-A-R-C, not M-A-R-K.
Yep.
Stevens with a V. I think it's .net. So, yeah, he's kind of run with that one, and it has worked really well. And I know typically what happens if you have a pretty savvy prosecutor, they'll normally jump in and interrupt the process and say, Your Honor, I'm sorry, before we continue, it looks like we don't have the required paperwork to continue today, so we'll have to ask for an adjournment. And that takes it away from him having to answer the question. And it also then gets it out of the courtroom for that date. What happens next is how you deal, because they'll probably try and set another court date and overrule you at that point.
Yeah,
so,
if you look at,
no, go ahead, John.
Yeah, if I just want to expand on this a little bit more and give people some cannon fodder to play with. If you look at the 7 elements of jurisdiction and the 12 assumptions of court, which we touched on the first and second shows, and again sort of briefly on the third show, there's a lot of tools in there. If you disassemble those, you cross-reference those and disassemble those things. And what Carl was just speaking about, I believe, is the third or the fourth element of jurisdiction is the defendant must be clearly identified. So when you walk, if I wouldn't walk into court, they would have to drag me into court because I know they're not talking about me. So one of the first things that's going to come up is, who the hell is this on this piece of paper? Right? Identify this individual that you've got listed on this paper. Is this a fact or a fiction? And I would ask the question directly. According to the Canadian Styles Manual, this designates a commercial fiction. Are you claiming I'm a commercial fiction? Right? And identify the defendant. It's required. It's part of the 7 elements of jurisdiction that must be fulfilled. So they can't really sidestep it. If you do this the right way, with sufficient strength and conviction, I would venture to guess that they're just simply going to make the thing go away. I mean, some people have done this where, will the defendant please stand up? And the guy pulls out his birth certificate and goes, here's the defendant, and puts it on the desk. And, a number of people have done this, and the stories they tell is amazing. It's just, you watch faces drop. People turn white. Horrible sounds coming from the other bench and such, because that's exactly who they're looking for.
Actually, I'm sorry, just wanted to butt in on that one,
Mm-hmm.
John, because we've talked about Keith and his court case.
Yep.
He did that, and his, as far as I know, is the only video that I've seen where that was apparent, and that line of process took place, where Keith actually brought out the birth certificate and gave it to the court and said, "This is who you're looking for." And the judge said, "Well, that's yours. Are you sure you want to give that?" And he said, "No, it's not mine. It belongs to the state, whoever." And that's when the judge stood up, bowed, left the court, done and dusted. But that was on video.
Mm-hmm.
The other occasions, I think, where this has happened, I don't think there's been video evidence of that particular process. Just testimony after the fact that people have done this
Yep.
with those same results. So I think the court cases where people are really, really winning is when they bring their birth certificates with them, and during the early stages, they give that to the court and say, "Here, this is who you're looking for." That's when shit happens.
Yeah, and so I'm not going to blame these people for doing that sort of stuff. It's totally up to them. I mean, it's their livelihood, their freedom that they're playing with here. But I'm looking for people who are ready to expose this in a big way, right? A lot of the cases that we've seen, they're scheduled for 9 a.m. You show up at 9 a.m. You sit there until 4:30 when the whole room is empty, and they make sure that the room is empty so nobody sees this stuff. If you have a gallery, if there's a bunch of witnesses there, claim the witnesses. Turn around and talk to the gallery and says, is there anyone here who does not wish to be viewed as a living witness? And watch the reaction of the officials in that room. They're going to freak out. He'll probably clear the court at that point, at which point you can stop and say, "No, you're not clearing the court. These people are my living witnesses. They are here on my behalf. They're part of this now, so they can't clear the court." If you really start ripping these things apart, if you look at the 7 elements of jurisdiction, take the first one, take 3 weeks and tear it apart. Think about the ramifications. Think about how it affects everything that you're going to be doing. And you will find the ways to bring this out that are correct, that are honest and honorable, and are going to really throw a wrench in the works. Like major wrench in the works. But like Keith did, Keith wasn't worried about exposing the system. I mean, he did. He showed a very clear demonstration that the system is screwed up and we are the ones with the power, because we are the only living flesh. We are the we're the highest authority in that room if you know who you are. He demonstrated that very, very clearly. What's not on the video is before anything happened, he seized the bailiffs of the court. He talked to the bailiff. He talked to the head bailiff. He told him, "I'm here under common law jurisdiction. Do you understand what that means?" The bailiff sort of sheepishly said yes. At that point, the bailiff works for him. And that's why he didn't get surrounded by big guys with guns, because they were now working for Keith. This came out. I'm going to have to talk to Peter, or talk to Patrick, and because see if Keith's written statement after the fact is still available. But he goes into great detail about what he did and why, and the effect that it had. It was on the World Freeman Society site for a while, but that's all been changed. I don't know if it's still there or not. But if it's something simple, $100 speeding ticket, big deal, right? I mean, $100 is $100. It's going to hurt some people. Some people aren't going to care. But something like that's pretty minor. If they slam the gavel down and said, "You're guilty, pay it," just pay it. No big deal. But you can have a hell of a lot of fun before that happens. And something like that, you can expose the contract, which is an invalid contract, by the way, because there's no full disclosure, there wasn't a meeting of the minds, whole bunch of things wrong with that contract. The fiction, they're not looking for you, they're not looking for the flesh and blood, they're looking for the fiction. So, are you John Anderson? Well, which one? I mean, there's lots and lots of them out there. I want to make sure you have the right one. Which one are you looking for? And I brought this up a couple of shows ago. Take your time. When they ask you a question, do not react. Respond instead. And take your time. Take a breath. Think about the question. Think about the ramifications of the question. And answer it in such a way that causes more problems for them. Answer it, if you're going to answer the question with an answer, then do so so that it doesn't cause you any more issues. But you're better off to answer the question with a question. Ask for clarification, because you don't know what language they're speaking. And we can't stress this enough. They are not speaking English. It's pure and simple. The words they use mean different things to them than they do to you. And unless you make that clear, they're going to use that language against you, right? Remember their Miranda warning. Anything you say can and will be used against you. Not may, not could, will be used against you.
Now, we brought something up a couple of shows ago, didn't we? Because there was some interesting information that neither one of us were actually aware of until I come across it myself a few weeks ago. And that particular question, taking your time, even something as simple as the judge asking you in a court case, Mr. John Smith, how do you plead? And we brought up, because previously we always assumed that they were talking about Mr. John Smith. Now, the fiction, not the living person, not the living being. But as it turns out, we now have reason to believe that we should also be questioning the word you in that question. Because we now understand that in the language, it's plural. You is not singular. Ye is singular. So his correct statement would have been, Mr. John Smith, how do ye plead? And that grammatically would have been correct. But now we understand there's a third party in this whole thing. There's the living being. There is Mr. John Smith, the fiction. And we now have you as a third party. And by answering the question, you're creating joinder, because you're accepting that the living person is a party to you. You're accepting you. And the question actually came across, Mr. John Smith, how do you plead? Not Mr. John Smith. Not how does Mr. John Smith plead, it's Mr. John Smith. The judge is asking Mr. John Smith, how does you plead? And then you answer as the living man, creating joinder.
That's right.
So even that very simple question the judge has asked can get you a whole bunch of trouble, because you didn't know the proper definition of the words that were being used. And one so simple. And another thing that I brought up in the past, Bill Clinton, he was going through his hearings, and the statement that he made that went viral, depends on what your definition of is. Something as simple as the word is, but it does have a definition, and it has a different meaning depending on the context that it was put in. And he brought that up during his deposition. Mm-hmm. So the simple words like is and you are not what we think they are. So how the hell can we ever expect to comprehend what's going on in a courtroom?
Well, the way you comprehend what's going on in the courtroom is you question it. And if it get to the point where they say, "Well, how do you plead?" Then I would question that, right? Which John Smith are you referring to? First of all, because there's many. Are you talking about this living flesh being that's addressing you at this moment? Or
well, that comes into the question: are you addressing me? That could be a direct
yes.
question to, or an answer in the form of a question to his question to you.
That's right.
Also, you could say, well, what is your definition of you?
That's
and
right.
Where are you getting this? What's the source of that definition?
Yeah, and
I'd love to see a courtroom where that question's asked, because I'm sure that there would be total chaos. I'm sure there would.
Yeah, I'm trying to get across the idea of what's the word I want? Precision of language. And we sort of touched on this a little bit with the quantum syntax grammar, which is incredibly precise. But when you're speaking orally, the quantum grammar doesn't quite fly. That's for written documents. But again, the concept is the same, and it's that precision of language that is very important. If you ask a question which is even the slightest way ambiguous, these folks are trained to pick up on that ambiguity and use it. So when you ask them a question, make sure that it's very, very precise. And this is why when I bring up the examples, like, are you referring to the flesh or the fiction? And I mean, every time they state a name, I would be asking that question. And if they get upset, I'm going to say, okay, I'll make it very, very simple for you. If you're addressing this being of energy inhabiting this flesh body, please address me as sovereign. Not Mr., not Sir, sovereign. If you address me in any other way, I am going to assume you're talking about some other entity. I mean, the summons is just an invitation. It's an invitation to contract. With any contract, you can write your own terms. So you can write that into the terms of the contracts. I'd be happy to come to enter into contract with you. Here are my terms. And you give them terms, and which now puts the boot on the other foot. If they refuse your terms, you now have lawful excuse to say, bugger off. I'm not going to play in your game. There's lots of things you can do before this ever gets anywhere near a court. And understand, it's all contract. Everything is contract. You are not obligated to enter into a contract. If you've caused harm, loss, or damage, yes, answer for it, certainly. I do not advocate in causing harm, loss, or damage to anyone, including them, without just cause. Now, if they're going to harm you, you have a right to defend yourself, certainly, but with no more force than is absolutely necessary. But when you realize everything is contract, when you realize these documents do not generate an obligation, they're simply an offer, that changes the game too, because now you counteroffer. Conditional acceptance. We brought this up a number of times, and whenever anybody makes a apparent obligation upon you, accept it with conditions, and make sure that the conditions are reasonable, first of all, honest, honorable, but ones they do not want to have happen. And chances are they're just going to go away. They won't bother you anymore. And they'll test you. Definitely, you will be tested. There's going to be a number of times when you're going to think that if you don't just acquiesce to their demands, that they're going to do you in. And that's a risk you got to take. I mean, it's up to each individual whether that's a risk they want to take. But like I said earlier, sacrifice is the measure of credibility. And anybody, doesn't matter who they are, how awake they are, how asleep they are, it doesn't matter. They get it. They understand that the person who's willing to risk everything is probably the one in the right. And because the criminals don't risk anything, they use intimidation and extortion and threats and violence, and there's no risk in that. The risk is exposing all of that. And that's what we need to do. That's the thrust of this show, is to give people tools, give them incentive to expose, ask the questions. Don't just assume they know what's going on, because pretty much every single time you don't know what's going on. Not, at least not fully. So question it. Question everything. Like I said, Mr. John Smith, how do you plead? Well, this Mr. John Smith, I'm not a Mr. So are you referring to this flesh being, or are you referring to this fiction? Well, I'm speaking to you, am I not? Well, by you, what do you mean by you? Are you speaking to this flesh fiction? Yes or no? And he's going to get really nervous at that point, and probably get flustered and start doing things, because you're taking him off script. You're forcing him to think for himself, and they don't want to have to do that. They just want to follow the script and play the game and get paid and go home.
Well, this is where they get into the realm of the threats at this point, because as you and I both know, then are you being difficult, Mr. Smith? Because if you continue with this line, I'm going to have to hold you in contempt of court.
Oh, that's a really,
the response is.
That's a really fun one. Well, first of all, if they ask, "Are you being difficult?" say, "No, I'm trying to clarify the language, because I don't know what language you're speaking, and I know that you play word games, so I want clarification. I want this to be clear. This is one of the 7 elements of jurisdiction. I need to understand this clearly." Which puts you in honor again. You're not. It's an honorable thing to want to have it clear, have it on the up and up. Contempt of court. There's 2 contempts. People don't understand this. There's 2 types of contempt of court: the civil contempt and criminal contempt. Civil contempt means you're in breach of a contract. You're willingly breaching a contract. Criminal contempt is you're willingly causing another harm. So question it. Contempt, cool. Which one? Civil or criminal? Civil. Well, what contract am I breaching? What contract are you claiming I'm in breach of? It's criminal contempt. Well, what harm are you claiming I'm causing?
Yeah, bring forward the living complainant.
That's right. That's another one. The charging instrument. 90% of the time, they don't have one. Right? They don't have the requisite paperwork in their rules to be able to proceed with what they're doing. And very few people demand it. Where's the charging instrument? Bring forth for my inspection, because I don't believe you have even the authority to be questioning me in this manner. And there's so much stuff.
Well, this is where we get. Yeah, this is where we get into the realm of standing and jurisdiction.
That's right.
Do you even have standing to bring a claim against me? And then we're obviously into jurisdiction again. So once you have an idea and a knowledge of the 7 elements of jurisdiction to start off with, and also in the fact of standing, where standing comes from, what it is legally that allows them to make a claim against you, you can rip their system apart. Because, traffic cameras, they're all over the place in the UK, and they're getting more and more over in North America too. But traffic cameras, you walk into court, say, bring forth the living complainant so that I may address my accuser.
Yeah. Or simply ask, stand up and say, who here swears to these charges? Because someone, according to the 7 elements of jurisdiction, someone must swear to the charges. Some living flesh has to take responsibility for those charges. Otherwise, what they're doing now is they're just making up shit. It's not even on the books. They just make it up and charge you with it. And nobody says, well, who's taking responsibility for this? And that's what that's intended to stop.
Well, they brought this into effect a long time ago, John, for the simple fact that when they brought up corporations, when they gave corporations a legal status, what was happening in the initial stages were corporations were making legal claims against living humans.
Yep.
And of course, because there was no other there was no other living complainant on the other side that could take responsibility for those allegations, it just became spurious and vexatious and stupid. So then they brought the rules in that say, no, you're not allowed to do this. There has to be a sworn complaint by a man. And it can come through a corporation, because a corporation can sue a corporation. That can happen.
Yep.
But a corporation can't sue a living man.
Yep.
Unless there is a living entity signing and standing behind that corporation to accept the responsibility for the allegations being placed. Because if those allegations turn out to be false, then somebody has to stand up and be responsible for that.
That's right.
Either in the case of perjury or, anything else. So tort damages. So then you're into a new realm there.
Yep, and that's then you're starting to bridge into common law, and it can get really complicated if it gets that far. Hopefully, with the sufficient research and taking apart the process that you're involved in, you'll never get that far. So it really doesn't matter. That's kind of what you can do if nothing works. I mean, it's a good one. You really should know it. You should know that a corporation cannot go after living flesh because a corporation is an idea. It's a concept on paper, and you can't call the corporation to stand. You can't question it. You can't make a deal with it. You can't, outside of court, you can't say, well, if you have an issue,
let's go for a beer. That's one thing
exactly.
You can't do to a corporation.
That's right. If you have an issue with someone, if you've caused them harm or they've caused you harm, you two can sit down and work it out and come to an amicable solution without having to go to court. The court should only be there if you cannot solve it yourself. Which nobody even bothers that anymore. They just lawyer up and it's all bullshit and it's just money and it's a huge racket. It's ridiculous. If you have an issue, deal with it yourself. If a corporation has an issue with you, then you have to handle it a little bit differently because you can't go and have a beer with the corporation and sit down and work it out and say, hey bud, what's up your ass? Because I really didn't do anything to you. Where's your issue? Or, sorry, I did it. How can I fix it? Right? Either one or the other. It's just a juristic unit. It's all it is a concept that has been given the status of a person, so that the corporations, because the corporations are everything right now, so that the corporations can obtain certain rights that were prior to limited only to flesh and blood people, and which is ridiculous. I mean, it's when you really dig into it, it's just totally stupid. But Peter asked, how do I enter into a driving contract that doesn't make me obligated to pay parking tickets? Peter, those are two separate systems. You don't have to have a driver's license to get a parking ticket. One is a state contract, and the parking tickets is a municipal contract. In order for someone to actually be liable for a parking ticket, they have to be in contract with the city that's issuing the ticket. And pretty much nobody living in the city is an agent or employee of the city. If you really want to dig into that, have a look at the limits of corporate bylaw. because that's what parking is. Parking tickets are a bylaw. And a bylaw is a rule of a corporation for internal governance. So if you're not part of that corporation, who cares? Doesn't matter. Making that work is not nearly as easy as you think, but that's the basis behind it.
Yeah, because typically what happens is, of course, you've got men and women behind those local municipal government offices and bylaw offices, and most of the bylaw officers are ex-cops, or at least they...
or wannabe cops.
The other way around sometimes too. But yeah, typically they have a set of rules, and they believe they've been given a certain authority to be able to carry out this set of bylaws and issue these tickets. And once it's been written and given to you, they don't give a crap. It's out of their hands, and they'll never do anything to make changes to it. Their response is, well, go to court.
Yeah, Peter asked, but we are agents of the municipal corporation, no? And depends on how you look at it. Did you agree to be an agent of the municipal corporation? Are they paying you? Right? The municipal corporation is no different than Walmart. So when you walk into Walmart to go shopping, to buy a blanket, are you subject to the statutes and bylaws governing the employees of Walmart? No, of course not. You're a customer. You're the reason why Walmart exists is to service you. Just because you live in a town doesn't mean you are an agent or even joined to that corporation that runs that town. They're there as a service organization, and they're there to service you.
Well, the closest you could really come to that would be in the case of property taxes, and that certain parts of that payment go towards the local government for services rendered. But again, does the fact that you pay that have anything to do with you being an agent of the municipal corporation, the local township?
Well, property taxes...
Can you make that claim or not?
Property taxes are, if you actually read your paperwork, property taxes are rent because you don't own the property.
Mm-hmm.
Now, I don't own property, period, at all. I don't even claim to own property. I am under a private contract with another who owns a property, and so none of those ridiculous little rules even apply to me because I'm not in any way joined to it. Now, this is another really complicated, scenario or system, which there are outs. There are ways that you can protect yourself in this situation. But if you've registered your property, if you have willingly, knowingly, and intentionally registered your property, you've just handed it to the state or the city or the province or whatever entity claims authority in your area. When you register your children, Carl put a post up. I didn't watch that guy's video because I already know this stuff. But for those who think that we brought this up and we don't know what we're talking about, here it is. It's right there in black and white. It's clear as a bell when you go and look at it. If you register, you are signing away your right to control of it, of anything. So when they demand you register, question it. But don't question the frontline guys because they haven't got a clue. They're just following a script. They've been told, you got to do this, do it. They don't know why. They don't have any background in it. So there's really no point unless you want to educate them and then ask very gentle questions that are just going to get them to go, wait a minute, I got to think about this. You have to go to the higher ups. You have to go to the CFOs, COOs of whatever corporation you're dealing with and question them and get them, put them in a position where they have to answer questions they don't want to answer. And in that way, you get lawful excuse because we have to generate this lawful excuse. This is in statutory regulations. It's in the statutes of Canada where they actually use the term lawful excuse. If you want to look it up, I don't know if you could find it in the search in Canley, but I know it's there. I've seen it. But then again,
they
they've
use the
changed.
phrase typically within the first sentence of most of the legislation that they bring out.
Yeah,
When it comes down to it, without lawful excuse, a person, blah blah blah.
Yep.
And it's written right into it.
Yeah, but again, they change stuff all the time. There used to be a statute, 33. I can't. It's part of the criminal code about protecting properties, and up until about 3 years ago, it was written in the legislation that you had the right to protect your property. That's now gone. It's been redacted. It's been removed from the criminal code. And they never bothered telling anybody about that stuff. So, as soon as you think you have the game sussed out, they change the game. So you're chasing a moving finish line all the time on this. But rather than chase the finish line, why not expose the game right from the beginning? And that's what that's where I'm pushing a lot of. You'll probably notice that if you listen to me long enough, is that expose it all. Come up with the questions, look at the situation you're in, look at what they're demanding of you, and formulate questions which expose that as the complete pile of crap that it is. Because 90%, unless you've caused harm, loss, or damage, it's total contract, it's all a pile of crap. And unless you have knowingly, willingly, and intentionally entered into that contract, knowing full well what your duties and responsibilities are, the contract is void, and by all means, destroy it. If you have entered into it knowingly, willingly, and intentionally, it is dishonorable to destroy it because you agreed to it. But a lot of contracts, it's not revealed exactly what you're agreeing to. And in these situations, most definitely question it. I mean, this is back to personal responsibility. If you borrow your neighbor's lawnmower and you agree to bring it back with the blade sharp and the deck all clean and it's full of gas, and you don't do that, you're in breach of that contract. Deal with it. If you borrow the lawnmower, he doesn't ask for anything else, and he doesn't say bring it back sharp, and with the if that's not part of the contract, and you do, and he tries to pin you to it, then you could say, look, sorry, I didn't realize that was part of the contract, and you work something out from that point, trying to find middle ground. Or you can just tell him to get stuffed. That's not what you required, and you'll never get to borrow it again. Know what position you're coming from. Know clearly what position you're coming from. If you've agreed to it, if you knew it was coming and you have agreed to it, then deal with it. You don't have an out. If it's something that was hidden and you never saw it coming, then the contract is void. You're not subject to it because the elements of a contract, we've touched on that. There are certain elements that must be in place for a contract to be valid, and one of them is full disclosure. All of the terms must be clearly brought out so that everybody understands the terms of the contract, which makes sense because if you enter into a contract and all of a sudden there's a whole bunch of new terms that you never knew about when you entered into the contract, is it the same contract you entered into? Certainly not. So it's a new contract.
We have to I'm just going to say, John, we have to just elaborate on that a little bit, because this was an argument that I had with Heather when she was talking about, legal contracts and this is how it is. That's not entirely true because, we're aware that there are such things as performance contracts and other types of contract that are still legally binding simply because we acted. Even something as simple as credit cards and things like that, they are not necessarily meeting of the minds, 6 elements or 5 elements of a contract, binding, lawful, legal, simply because you signed, you got credit, you used the credit, and then you made payments. That means that you're in effect
In contract.
in operation of that contract, in contract, because you acted, you performed under, whether it was a one-way contract or not, because they all are. Here's the terms and conditions. If you don't like it, piss off. That's basically where they come from. So you usually end up signing and you follow, and then we end up in trouble later on. But that's part of the process that we have to be aware of too, because there are different contracts. So we can't just say that these 6 elements, 5 elements, wherever you look, are the be all and end all of contracts, because technically speaking, that's not really true.
Yeah, well, there's performance issues that you have to look at as well, which are all parts of the elements of the contract. But that brings to mind this fella in Russia. I don't remember his name. I just remember the story behind it. The credit card company sent him an application sent him the thing for the credit card, which apparently in Russia, it's everything, right? You sign it, it's the contract, it's everything. He took that, scanned it, reproduced the document so that it looked almost exactly the same as the original document, but it had his terms in it. And he rewrote the terms to favor him. And not to steal money, not to take anything away, but to actually expose and use it as it was originally intended to be used. Because if there's a number of places. We had this on the World Freeman Society. One banker saying, they love credit cards because it's a license to print money. Because they're double dipping, they're triple dipping with credit cards. It's ridiculous how that system works. But this fella rewrote the contract.
Well, the credit limit itself is actually the process of creating money, even though you never use it.
Pretty much.
Yeah.
This fella rewrote the contract, put in his terms, which favored him lawfully, correctly. Sent it back. They gave him a credit card, racked up, X amount of dollars, 30,000, 40,000, whatever it was. And then the credit card company took him to court, and he laughed big time. And when he got to court, he says, well, here's a certified true copy of the contract. And they read the contract, and they basically threw it out because the credit card company had no standing to sue because there was no provision for them to sue him in the contract. A contract...
He's actually just put a link to that. He's found it via Google.
Excellent.
So you can read it. It's there.
Excellent. You could do this with a mortgage. You can do this with a PLC. You can do it with credit cards. Any contract out there, you can put your own terms in. Nobody understands this. They think they get this piece of paper in the mail. This piece of paper is immutable. It's not. You can add your own terms. And as long as the terms are lawful and honest and honorable, you can't be blamed for it. I mean, like you can't get a contract and change it so that you can go and kill the CEO if he's an asshole. I mean, that's not right. I mean, don't even try to do that. But if specifically with the mortgage, like lots of people, I was thinking about this last night. There was a big thing coming out going, well, the mortgage is all fraud because the banks just pull money out of thin air. No, they don't. They don't pull money out of thin air. You, by signing the promise, by creating the promissory note, you are creating the funds that they are changing, that they are putting in on their books. Okay, the people who were looking at this didn't take it far enough. Now with a mortgage contract, you can put that in there. With the acceptance of the promissory note, the funds are created to fund this so-called loan. You can reverse the lender and borrower. At the beginning of the document, John Doe, hereinafter referred to as borrower, and the bank, hereinafter referred to as lender. Swap them around, right? Chances are they're not even going to notice whiteout on the page because they don't even look at these. They don't read these. I mean, you can do this. Anybody can do this. If you're going to do it, make sure you have the language. Make sure you understand and comprehend both in their correct forms, what you're doing and what those alterations are going to ultimately provide. Because you can make alterations that they could run with. I mean, if you're not really sure about the language, if you put in the wrong words or you put a comma in the wrong place, you can completely change the meaning of the sentence. I mean, you could take a comma out. Who's going to see that, right? Because they're not going to read the contract. They're not going to look it over. They're just going to go, okay, it's a rubber stamp, thunk. They've accepted it, just like they expect you to accept it without reading it. They're liable just as much as you would be. And once people start doing this, they have to go through and start reading the contracts. Now, if you do this, make sure it's not something you must have. Because if they do happen to catch it, they're just going to go, no, sorry, we don't want a contract. Have a nice day. Go away, and you're out of luck. You don't get whatever you're contracting for, which in some cases could be a really good thing. So, pick your battles. Be very careful of the language. Be very careful how you're going to address these things. But know that just because they have a fancy logo and they wear a suit or maybe have a funny hat on doesn't mean that they are not subject to exactly the same rules that you're subject to. In that, if they don't read it, they're still liable for it if they accept it. So that's another tool that we can use. That's a little extreme. Yeah, I mean, in some cases, they're probably going to get really upset if you do this and they catch you. But it's not unlawful. It's not illegal. It's simply a contract. And up until the point that it's accepted, it really doesn't matter. It's just a piece of paper. But once it's accepted, once two parties have signed off on it, then it becomes law, and that's a governing law between those two parties in that matter. So why be subject to one person's law? Why can't they be subject to your law as well? This is the point that I'm trying to get through here. And go ahead.
I was going to say another factor of contracts as well is that the typically they are only two parties involved. There can be more, but that's usually stipulated within the contract itself. But it's usually signees or signatories of the contract that are a party to it. One of the things that we've brought out in the past, and I know Danny jumps up and down when that gets mentioned, but the likes of the Constitution in the US. Everybody thinks that 300 million people are a party to the Constitution of the US and it protects their rights, etc., etc. No, it doesn't. It protected the rights of the signatories of the time, which I think was, 13, something like that. And their heirs and assignees, but the rest of the people, no, it doesn't. So contracts themselves are limited to the signatories of it and any assignees that are appointed within the terms of the contract. So if anything comes about a little later on, such as a third-party interloper wants to get involved in your business, then you better be looking at the terms and conditions of the contract that you signed. Because at that point, you could turn around and say, well, I don't recognize you. I don't know who the hell you are. You'd better confirm that you have any legal obligation to interfere in my private business between me and whoever it is on the other side of the contract. And if you can't show that, then goodbye. I don't recognize you. Go away. I'm not going to talk to you. And you have a legal right to do that. And this is part of, I know we're jumping a little bit, but part of a debt validation process where that can take place. But it's the same with any contract. Any contract, a third-party interloper is somebody who is interfering in your private business. And unless they've been given legal recourse to be able to act on somebody else's behalf as part of that contract, they have no right interfering in your business.
Yep.
So bear that in mind too.
Yeah, most people run into this with collection agencies, and most of the time there's a organization called whatliesinyourdebt.com that I'm aware of. I'm sure there's a number more out there, and they do touch on this, and typically what has been the process up to this point is when you get these things in the mail, just say, well, validate it. What's your claim? Where did you obtain this alleged debt from? Validate your claim, and they can't. They have no legal recourse to validate the claim, because typically what a debt collector will do will be to buy an alleged debt and then assume that they're going to collect on it. They really have no, you have no contract with these people, so you have no obligation to actually pay them, because they took it upon themselves to buy the alleged debt. Therefore, the debt's paid, and you don't owe anything. It's gone. It's finished. It's satisfied.
Yeah, and even if they paid 10 cents on the dollar, that doesn't matter.
It's still satisfied.
I mean, we could put it as exactly. The debt is satisfied. I mean, we could use an analogy. For instance, you loan somebody out there in the chat room $100, and you say, well, you pay me back over such a period, next 6 months. But then you sell that debt to me, and you might sell it to me for $70 because, already you've had $10 paid, but actually you need the $70 right now. So you sell it to me. So I give you $70, and then I go to the guy in the chat room and say, right, you owe me $70. No, he doesn't. The original agreement wasn't between him and me. It was between him and John. Now, John has been paid.
Yep.
The debt has been satisfied as far as John is concerned. And
Yep.
I'm out $70. But I have no legal right or recourse to claim that from you, the original borrower of that money, unless you agree. And that's what's happening. They threaten you. You say, oh, well, I owe the money. Well, yeah, you were originally giving it to John. And you might act all honorably, and they'll bring that out in the course of these conversations that, well, you took out the debt, so you're responsible for paying it back. Well, no, because contract law says your contract was with John, not with me. Until the point you agree to pay me something, then we have a new contract.
That's right. And
you're in trouble.
The part that really gets screwed up on this is when they go to court for garnishee. If you haven't questioned the validation of the debt, it is assumed that it's valid. And assumptions, presumptions rule in this system. You have to squash the presumptions, or they will be held against you. They will presume that you agreed to this, whether you have or not. Unless you specifically, unequivocally, and directly disagree, validate the debt. What makes you think I owe you anything? Show me the accounting. They're going to, the court will assume that you have agreed, and that's how they get away with this stuff. And that goes on the 12 assumptions of court, which is the first show we brought up. And if you just, the 12 presumptions of court. If you do a search on that on the internet, it's out there. Where is it?
I just posted a link, John.
Free Thought Project. I think it's posted a number of different places.
Well, I've just posted a link there in the chat, so
right.
They have a basis to search from there and go on from that.
Right, and if you don't step on these presumptions right away, they will stand, and you may be able to stomp on them later, but you're better off to do it right in the beginning and squash them.
Well, yeah, that's right. Anybody that comes to you, let's just go on the debt collectors for the moment. Anybody that approaches you and sends you a letter alleging that you owe a debt, first we have to look at the language again. You, mm-hmm. Who are they asking for? But secondly, you actually have, I believe, in most countries, 30 days to write back to them requesting validation of the debt. And there are a number of different ones available. I'm in the process of actually trying to help one of our little friends over in the UU room in regards to this. So there are different letters out there, templates, let's say, that you could use, and some are better than others. But you have to be fully conversant with exactly what it is that they're asking. So in essence, you have to know and comprehend how money is created, the process of money creation, what actually happens when you take out a credit card application, when you go for a loan, when you sign for a mortgage. The problem with a mortgage, as most people are finding out, you have something to lose. It's your home. It's where you're staying and living. And they have great delight in going through the process of removing you from your living accommodation, because to them it's a lot of money. It's a harrowing process as well, because many people think that because all the news came out and said that everything is illegal, technically, yes, you could say it is, but you performed on the contract. So there became an established contract. If you want to piss off somebody in the mortgage industry, take out a mortgage, go and move into the place, and don't make a payment, ever. Because if you don't make a payment, then you're not performing on the contract. As soon as you make a payment, you've performed on the contract. The contract is now valid. So you can go to court and say everything in the world about how illegal and fraudulent this contract is. Doesn't matter. You got the money. You agreed to pay it back. You have paid some back. So you've become a party to that contract. And the question in court will always be, did you get the money from the bank? Doesn't matter where it came from. Did you receive the money? Did you get the house? You have to answer yes.
Yep.
And at that point, they say, default judgment, case closed.
Well, there's
the guy or lose the house,
There is a wrench you can throw into that as well. And that is, say, awesome, I'm happy to pay it. Do you guys accept promissory notes? And
then we're into a whole new level of weird.
Well, I mean, they have to say yes, because that's cash money. That's the $10 bill that's in your wallet is a promissory note. And if they say yes, they say, well, what's
to know how to actually write a promissory note.
Well, no, you've already written.
What it is.
The point, Carl, here is you've already written the promissory note. So if they say yes, say, well, what's wrong with the promissory note that I generated to fund this in the first place? Nobody's brought that up that I'm aware of.
Mm-hmm.
Right? Because when you create that promissory note at the bank and the bank accepts it, it's paid. You have created the funds. All the bank did was change one species of money to another and hand it back to you. That's all that happened. Mm-hmm. So if you ask them, I'm happy to pay this. Have you, do you accept promissory notes? Well, of course we do. Well, then it's already paid because I created a promissory note for that amount right from the beginning. Now, if you want some more interest, I'll make another one and you write up a promissory note. This has been done, folks. There was a fellow in the States that did this. And he was in court. He was going to lose his house. He asked them, do you accept promissory notes? They said, of course we do. So he sat down, he wrote a promissory note, handed it to the judge. The judge looked at it, handed it to the bank, said, you're paid. Case dismissed. Mm-hmm. It is there. It is valid.
I was going to say, John, there was another one where that happened, where I'm not sure really where it went, but I remember somebody was approaching the judge by saying that they would pay what they legitimately owed when lawful money was available to make the payment.
Certainly.
Which is another way that threw a spanner in the works too.
Yep. Yeah, because right now all we have is debt. They're all debt notes. A promissory note is a debt note. A $10 bill is evidence of debt, not value. So you can't pay anything. Nobody's actually been paid for their services because all they've been given is a promise to pay. There is nothing to pay with. And which is
why I make notice on most of anything that I ever change that that this is a credit on account. This is not payment.
Yep. It's also why in my fee schedule, it is stipulated very clearly that I get paid in Canadian gold maple leaf coin at face value. Because that is the only lawful money in Canada, is the Canadian gold maple leaf coin. And if it says $5 on it, it's worth $5. They don't like that. They see that and turn white. Nobody has triggered my fee schedule.
Well, especially when the value of gold goes to close to $2,000 for an ounce of gold.
Yeah. And a $5 coin is, I think, a half ounce. If I remember right, or quarter ounce. I'm not sure which. But if it research this, look into this. Don't assume that what you have been told for the last X amount of years, however old you are, is even remotely close to what's actually going on out there, because chances are it's not even anywhere near it. One of the things that pretty much all of us who have been doing this research had to get over, one of the first things we had to get over is being lied to our entire lives. And if someone thinks they can get away with something and they can profit from lying to you, they're going to lie to you. Especially in a profit-driven society. It's just the way it is. So expect it. Expect them to use flowery language and odd terms that may confuse you. And if you do start getting confused, do start getting flustered, step back, take a breath, think about the question, formulate your own question to answer their question that is intended to clarify, because intent really matters. But in that clarification, you're going to expose. And the more people that we do this, the faster this whole thing falls apart and we get back to actual common law, honest, honorable living. And that's what we want to do. We want to get back to honesty, to honorability, to personal responsibility, personal liability. If you harm someone, answer for it. If you cause loss or damage, fix it. That's the right way. That's the honorable thing to do. And live your life so that you simply don't have to go through that stuff. I mean, it's not a hard thing to do, to live so that you do not cause harm, loss, or damage to another. But if you live in the statute world, you are constantly causing harm, loss, or damage to another. It's built that way. It's designed that way.
Yeah, that's how lawyers make their living. Mm-hmm. The legit. Oh Christ! I used to be able to say that. Litigious society that we now find ourselves in, where you get sued for just about anything and everything.
Well, yeah, in the States, it's huge. I mean, not everywhere in the States. I'm again making another generalization. It's not nearly so bad in Canada, because Canada's sort of a melting pot of people who didn't like where they were, so they came here, and that's one of the wonderful things I like about this country is the amazing diversity, the people who want to get along, for the most part. Down in the States, it's like New York City, so any of the big cities, you don't even look at people or they yell at you. And what are you looking at? You fucking, and they freak out. I mean, that's a trained response. It's a learned thing. It really has no point. It has no purpose. It doesn't protect anyone, because if you are a singular entity in an organization of millions of singular entities, you've got a million enemies. If you are a collective entity in an organization of a million collective entities, you don't have any enemies. Think about that for a little while. Mm-hmm. Community works. Community works, but you also have to have compromise. you have to be willing to give up in a community. Now, sometimes it's a little one-sided on, when you look at it in a vacuum, when you look at each individual situation, yes, it could be a little one-sided. Overall, throughout the span of time, as you go through this, it's going to even itself out. But it's, the lookout for number one. I mean, when that came out, how old was I? I was late teens, I suppose, when that came out or started coming out. And I thought, yeah, that makes sense. Kill or be killed, do unto others before they undo you, that sort of thing. And, I sort of embraced it. But I realized really fast that's a really bad way to be. Because when you're in a group and the group is cooperating and people are, not looking out for number one, they're looking out for the group, things work out so much better and so much faster and equitable for everyone in the group. It's pretty rare that, you're in a group that's a cooperative group. One person is actually going to benefit and everybody else is going to lose, which is the society we live in now.
Well, the problem I see on that one, John, of course, is that the community, small enough communities, anybody who's in it for himself really stands out and won't stay in that community very long. The problem that we have is that we now have cities of millions of people, and it's no longer a community, and the people who are willing to do this stuff, the psychopaths and sociopaths, they end up in the positions of power and control over everybody else. So, all these rich people are typically psychopaths, and all the poor people are the really good people, the honorable people who just want to go along to get along and don't want to be a part of this or can't be a part of this dog-eat-dog society. And because of that, they don't end up, getting the money, getting the possessions that this society dictates your drive is to go towards. And that's one of the things, again, that we have to move away from as an indoctrination. It's something that we're taught from school. That's part of what school is. It's the indoctrination process to be the drone, to be the dog-eat-dog kind of member of society, as opposed to being a good, caring member of the community. Even if it's a global community, it's a different way of thinking.
Yeah, fortunately, that hasn't really sunk in. I mean, yeah, if you just look at general day-to-day life, certainly it's there. But we also have very good examples of that falling apart. And if you look at how people deal with disasters, you want to see it. You want to see
inherently good.
You want to see a community come together. Look at a community in a disaster situation, and unfortunately, it takes that extreme to get people to cooperate and to work together and to build something amazing. Because what these people do during a disaster situation is phenomenal. And if they did that daily, we would have an amazing place to live. So yes,
Could we not say that's we're moving towards that now, though, John?
We are moving.
Society, well, no, not to the extent that every single day is an absolute disaster, but we're moving towards that simply because of what's happening in society, that there is now an ever-growing awareness from the poor people and from the good people that there is something very definitely wrong in this system, and that we're now being forced into acting in self-defense right now because of how much this system is imposing on our individual lives and freedoms and economic viability.
That's most definitely
it's happening.
Oh, it is happening. Yes, it is happening, and the universe is making sure that we get it. Now, we can either get it the easy way and realize it ourselves and just work towards it, or the universe will make sure we get it. And it will do anything and everything that it can in order to get us to that point, including disasters and all of this stuff. Please don't let it get that far. I don't want to see anybody go through that stuff. I mean, there are people out there that need a 2x4 upside the head just to wake up. Unfortunately, that's just the way it is. Most people out there, they can see it. I mean, several years ago, I used to go to the hot tub, the community hot tub, because I was living on the side of a mountain in a trailer and I didn't have running water and I had no showers. And so just in order to maintain some semblance of humanity, Wednesdays and Sundays, I would go to the community hot tub and soak in the hot tub and have a steam and talk to people and everything. When I first got there, it was really rare to find somebody that had a clue. I would bring up, they'd make some statement and I go, oh, there's an easy way out of that. And, try this, try this, try this. Oh, you're nuts. You don't know what you're talking about. Within 2 years, it was exactly reversed. Most of the people that I talked to had an idea. They didn't have the tools. They didn't know what to do, but they knew something was wrong. They knew there had to be a way out. There had to be something they could do to this. It's changing, and it's changing really fast. And if we can keep people out of what Peter got into, and that is the anger. I want to go hurt people. They've lied to me. I'm pissed off. We got to get him past that really fast, because that doesn't serve anyone. Doesn't serve you, doesn't serve them, doesn't serve the people who have harmed you. It doesn't serve anybody. And that entering into this in anger, in frustration, in fear, will not work. We have to get folks beyond that. We have to get them to go, look, I just don't want to play. Thank you for your offer. No thanks. I'm going about my life. I'm taking my kids to the beach. And when everybody does that, then the power of the control is gone. I mean, the analogies, a number of analogies have come up, but the one that's most prevalent is the folks in the cave. And you've got these people that have been raised in a cave. All they've seen is shadows on the wall. They're all fearful and everything. The door's wide open. They can get up and walk out anytime they want. But they are fearful. They don't realize they can do that. We can do that now. We're at the point where we can simply walk away. No, thank you. Have a nice day. It will be tested.
And that's the aim of our show, isn't it, John? Really, because we've come together. We saw the opening that we've been researching and fighting for so long. I mean, you've been doing it for longer than I have. But it's gotten to the stage now where there are so many people out there who really do know that there's something wrong, but have no clue on what to do about it.
That's right.
And the aim with what we're doing with this show is simply to be able to get them past the stages of grief into the acceptance stage, that, what's past is past. Learn about it, comprehend what's being done, never mind what was done, and then use what we're offering as the tools of knowledge to be able to stand firm and stand up against what is being done and what will attempt to be done in the future. And like you say, if everybody stands up and doesn't comply, it's like we said with Highway Traffic Act. Every cop gives a ticket out for a month. If everybody just said "fuck this" and said, "I'm going guilty,"
get right on it, right on it, no contract, and send it back.
Yeah, if everybody did that, it would absolutely swamp the system. It would overload it. Same with debt collection. Every debt collection agent, the first thing that they got would either be return to sender, I don't recognize you, piss off, or debt validation.
Yep.
You want money from me? Well, validate the fact that you have the right to ask me for money, because most people don't do it. They don't know that they have the ability to do it for a start, and this is part of the process that we want to bring out. There are tools for you to use. There are things that you can do. Fortunately, some of it's nice and simple. Unfortunately, some of it, there's going to be big time pushback because they really don't want this stuff out there. And in the case of the money creation process, that is one of the major legs of their system and their system of control. So if they lose that, then the stool falls over because,
and this isn't a new
the
concept.
others have no power.
Yeah, this isn't a new concept. This is something that came out late 80s, well, for me anyway, in the late 80s with cannabis. And the idea came up that, what if every single cannabis consumer took 2 grams, walked into the police station, dropped it on the counter and said, bust me. And wouldn't leave unless they got arrested and charged. I mean, it would totally screw the system. They would have to forgive most of it, which by their rules reverses that law. And it could have been very simple, but it requires large, big brass ones. And you got to be willing to give up. You got to be willing to sacrifice in order for this to work. And the same thing with the traffic tickets. I mean, yeah, most people don't go looking to get a traffic ticket. And I'm not saying go do something stupid just so they write paper on you. But if you do get one, no contract, send it back. I'm not going to deal with this, right? Make them, force them to go through the process to prove their claim. If you don't demand, if you don't cause them the need to prove their claim, then their job is really easy because they can just make up any shit they want and you're just going to accept it and bend over and take it without lube. If you force them to prove, you've made this claim, prove it. Show me your standing. Bring it up. Again, an element of jurisdiction. They have to prove standing. They have to prove they have a right to do what they're doing. Whether it's a contract, whether it's harm, loss, or damage, whether it's simply that you don't realize they have to prove it and they can get away with it because you don't question it. And this is the big thing.
Well, that's why the presumptions.
Exactly.
Because they've brought in the system of presumptions. And if you don't question that and you don't fight back and query the fact that how they're operating, once you understand jurisdiction, and I'm saying understand so that everybody else out there knows, let's say comprehend. Once you comprehend jurisdiction, once you comprehend what standing actually is and how this process is how the procedures for this whole process take place and the end results, then at any point in that early stage, you can throw a spanner in the works because you remove their presumptions. And at that point, you remove their standing, you remove their jurisdiction. They have no place to go. But again, you have to have the knowledge to be able to do this. And as John said, usually in court, it's chess at 80 miles an hour, and you have to have a big set of swinging brass ones to stand in front of a courtroom full of bailiffs who don't know how to smile, and judges whose every day is to trick you and intimidate everybody who stands in that room. And some rooms are really, really scary because they're made to look that way. They're not just little offices. They're big, imposing, dark wood. Everything's about procedure and law, and the whole process of being in that damn room is intimidating, never mind what's going on in there. So if you're not used to doing that, then it's a really scary place to be. But we have to lose the fear. Yeah. And the only way you can lose the fear is to have the knowledge on how to proceed. It's fear of the unknown is pretty much what it is. Once you have the knowledge, it's no longer unknown, so it's no longer fearful.
Yeah, but also...
But there is a process that you have to go through.
Yeah, also something that everybody needs to understand is the only way a lot of this stuff works is if you have witnesses. If it's done in a vacuum, if it's done behind closed doors, they're just going to alter the record and you're going to be gone and they'll disappear you and nobody will hear from you again. You have to be public. You have to have... It has to be in the spotlight. And I mean, I hesitate to use the word, but the light worker community has brought this out in that evil cannot exist with a spotlight on it. So make sure that if you're going to go through these processes, that you carry a really big spotlight. You have witnesses, you have people following you, you have people who are going to be there. And it is possible to do this without having the witnesses. It's really difficult. You got to really know your stuff. One of the things that came up fairly early on in this research is the invocation of a court of record. Now, a court of record is by definition a common law court because it is public. And on and for the record is a very important term that you need to get, embedded into your head. So anything you need to make sure that people know about, on and for the record, and so on and so forth. If you have a group that's coming with you, invoke them as living witnesses. And, I am here in the sight of living witnesses to question your jurisdiction, to question these charges, to seek clarity on this issue. There's a number of different ways to do it. And again, language is important. Don't use the word case, use the word matter, because case has a very specific meaning and they will turn that back on you unless you know exactly what you're doing. If you
John,
really think
just
about,
to follow up from what you were saying there, John,
Go ahead.
I had a conversation. He's in the chat today, actually, but I had a conversation with somebody yesterday, and I'm not going to mention his name unless he wants to identify himself later. But the whole process of what you've just mentioned there, I spoke of simply because there are ways of doing this as well, and there are certain things that even if you're operating within the courtroom, that there are certain things that you have to identify are terms that are useful to you as well. One of the main things, the word object or objection, I object, that puts a hold on a process of a court case or of a trial, simply because they have to deal with that objection before they can continue. But if you just say, oh, wait a minute, that's not right, or you use some other term, it means nothing.
That's right.
Objection or I object does. It's a very explicit term and they have to deal with it. So if you don't agree with something, say, I object.
Yep.
And, they'll say, well, what do you object about? Then maybe tell them what you object about. But you have to say that. The other thing is for, I mentioned the term now, for motion. Use their terms. If you want the court to do something for you, you have to motion the court. You can't just say, well, I want this to happen. You over there, read this out. And no, I motion the court. That is a term that they must act on as well. If you motion the court, then the judge specifically has to deal with that motion. And it can be a verbal motion, or it can be a pre-filed written motion. And if there is a pre-filed written motion that you've got before the court, they should be dealing with that before anything else takes place. So if you're going to walk into a courtroom with a pre-filed motion, you just say, Judge, there is a motion filed with the court. Can we please deal with that matter right now?
Yep.
Before anything else. Yep. You have to know this to use their own words in the situation of a courtroom, plus the extra stuff that we're telling you on how to deal with the situation. If you want the court to work for you, then you have to know how it operates. Mm-hmm. So you have to learn this too. So,
yep, and
carry on.
And some of the little tricks. It doesn't happen nearly as much in Canada, but it's down in the States. It's quite often, and they'll put you up on the stand. And do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God. You have to answer no. You don't know the whole mm-hmm. truth. If you answer yes, then if you swear to it, you're swearing to something that you simply cannot produce. So you're perjuring yourself.
Actually,
right there.
I remember something that Rob said about that one, John. He said, no, I can't tell the truth because if I could, I'd be in that book, not with my hand on it.
Yeah, and that's with his hand on the Bible. If I knew the whole truth, I would be in the book. And think about who you are. I mean, a lot of this comes down to knowing who you are and where your limits reside. I mean, you know the truth from your perspective. That's all. In reality, no single individual can know the whole truth, because the truth is different for every person that observes whatever situation it is. And I wish I could remember the books. There's a books that sort of touched on this, and the premise was there was a group within the book who could only I'm going to use the word testify to what they actually physically observe. And one of the examples that came up when this was brought up was they were talking about a house, and this lady could only see one wall of the house. She couldn't make the assumption that there was 3 more walls. So from her perspective, her truth was there is one wall on this house. I mean, it goes into greater detail in this books. I wish I knew which books they were. Maybe somebody who's listening has heard it. They can stick it in the comments. I'd love to be able to. I'd love to read it, because I'm sure it would clarify this this concept, this way of thinking to a much greater degree than I'm capable of at this time. But it comes down to know what you know what you don't know, or have at least an idea of what you don't know, and question it. But make sure when you question these things, especially when you're questioning it to officials, that you already know the answer. If you don't know the answer, you won't know if what they're telling you is real or bullshit. Go ahead, Carl.
We're going to repeat this. Sorry, I was going to say we're going to repeat that several times, because if you're going to communicate with these people either verbally or in a written form, don't make statements that you can't back up.
Oh, big time.
And don't ask questions that you don't already know the answer to, because those questions, they're going to get you in trouble, potentially. And certainly the statements will definitely get you in trouble, because potentially you're making accusations, which doesn't go down too very well.
Well, the point about this is, if you ask a question that you don't know the answer to, and they give you some bullshit answer and you accept it, they're going to know you don't know what you're talking about.
Mm-hmm.
And at that point, you're done, because they're just going to walk all over you, because you didn't stop them and say, look, that's bullshit. I already know that is not true. And it gives them the opportunity to basically take you for a ride.
Yeah, the other thing that I actually brought up as far as court cases were concerned as well, that I know this was mentioned in the Freeman Society, but during the course of conversations, but this one really works well. You talked about having witnesses, which you almost always must have. Don't go in there by yourself. Don't go in there with your missus or your husband and think that everything's going to be okay. It's not. You're going to have to go in there with a number of people. And another trick that I found was quite useful was have somebody there, or a couple of people there, with legal notepads. This is usually the big yellow notepads. And, have them have them well dressed, and if anybody asks questions, or just, these are some paralegals that are here just to take notes on the case. They're working for me. And in addition to that, have a couple of people that look like the reporters, carrying notepads. And if they ask who they are, they're reporters. They're reporting on this story.
Yeah.
And if you have other people there, and you should, the more the merrier, say, these are just my living witnesses. They're here to support me and witness the case.
Yep.
All of this goes towards helping you in a courtroom situation, because if they perceive that you are able to witness and record what's going on, they will do everything in their power to either act accordingly, or they will, because there's bullshit going on in the background, they will adjourn the case, get rid of the case, dismiss it, whatever. Depends on what kind of case it is and what's going on. But the more stuff that you can do like that, the more power to you. If you stand there on your own with two swinging brass ones, doesn't matter. They will have the control in their eyes, and they will do everything that they can to overrule and override any argument that you might have, right or wrong.
Yeah, I mean, by extension, this comes back to shine a light on it. And if you have, if the bully is only going to operate in the dark. He's only going to operate when he doesn't have a group around him, unless the group supports him. If you're in the gym and the bully is acting up and there's 300 people in there who are watching what he's doing, he's going to act differently. He's going to change the way he does things. And we've seen this with the police. When people videotape the goings on with the police, they change how they do stuff. Now, they want to take your cameras away, and a lot of people don't pick up on this, but that is tampering with evidence. When you're filming the police, you are collecting evidence. And you're in a very, I don't want to say precarious, but a position of extreme responsibility at that point. And if they come and you can't film the police, well, I'm sorry, I'm collecting evidence. It's going to change the game. They will, at that moment, change how they deal with everything. And if everyone that's filming the police uses that exact phrase, or one similar to it, I'm sorry, I can't allow you to tamper with evidence, then things like filming the police are going to get a lot easier. You should use
that after, I think, John, because, what you said first is, by all means, I'm collecting evidence, or I am videoing the scene. I'm not photographing the police specifically. I am videoing the scene to collect evidence. And if they push the issue, well, give me the camera. You can't film me. You can't film the scene. Then you should go with the response of, are you at this point attempting to interfere with evidence?
Yep.
And at that point, they know exactly what interfering with evidence is, and they should back away and just leave you alone.
Yep.
If they push it at that point, then you need some more witnesses to stand around saying, hey, this cop over here, he's trying to interfere with evidence. I'll tell you, he'll disappear real fast if that get a few people shouting that one.
Oh,
again, you have to know this.
His boss is not going to be happy with him at all. I mean, expand on this a little bit. When you get the invitation to court and you send them back your terms, one of your terms should be that 3 independent video camera witnesses recording the ongoing proceeding for evidentiary purposes and to ensure no tampering of evidence can take place, right? Term it in such a way that's an honorable thing so that anybody who reads it's going to go, yeah, that's a really good idea. And if they say, no, you can't do that, well, why? Are you intending to tamper with the evidence? Are you intending to change the record? This whole thing is intended to maintain the record so that it cannot be altered. Because we know they alter the record. They do it every day, all the time, constantly. It's because they have the only record. They can do whatever they bloody well please with it. So I would put in as one of your terms and conditions that there's going to be no less than 3 independent records taken to ensure that no tampering can take place. I mean, think about how you can honorably and rightfully make it impossible for them to use their deception and their lies to cause problems. Because that's all it is. It's deceptive acts and practices. And they've got it down to a fine art. And because they're the only ones with the record, they're the only ones with any evidence after the fact, they can basically do whatever they want, because anything that they don't want seen or heard, they just remove it from the record.
Okay, John, it's probably wanted to do this about 15 minutes ago, but do you want to bring anybody in maybe and see if
I'm sure.
questions about stuff?
If anybody wants to jump in and change the subject or complain or bitch or tell us we're off track, doesn't matter. Come on out. See, Danny's in finally. Still only
Yeah,
got
she
in
got
for the
to
last
spend
half hour,
a few
but that's
minutes.
okay.
Yeah.
I just randomly appear when no one expects me.
Well, that's cool. Keeps
Best
us on
way
our
to be.
keeps us on our toes. Keeps us honest.
Yeah.
No, I've been enjoying listening to you guys. I'm sitting here doing all kinds of horrible, boring, disgusting paperwork and listening in. This is awesome.
Good.
I'm
We
glad
like
we
it when people enjoy the show, don't we, John?
I'm glad we could help.
Exactly.
That's awesome. Hey, Mark, did you want to come out and talk about what you and Carl were talking about? If you need any clarification or you want to bring something else up, you're most welcome to. Or I've got to fill up 15 minutes, or I'm just going to keep talking, and that gets really dull after a while.
Yeah, hi, John.
Hi, Mark.
Yeah, I was talking to Carl yesterday because we're in a predicament where we went to a hearing and it was behind closed doors. Lisa said that the judge actually told us to shut up. And what Carl says, about motions and so forth. Well, I didn't know none of this, but we go back on the 13th of September, and by Christ, these past 3 months and what I've heard and learnt is phenomenal. And I'm going to put today's discussion into practice. I know we shouldn't take it as law or whatever, but when you was talking about earlier on, people have to open their eyes to see what is really going off. Well, to me, this all makes sense because it's the people that I'm dealing with, these corporate companies and the UK government, and what they're trying to hide and cover up. And the judge having a peculiar interest of £200,000 worth of shares with one of the claimants that we're in the courts with. I mean, it's just mind-blowing what these courts do. So I'm going to go back well tooled up, if you know what I mean. But listening to you guys, it's just information. And I do appreciate it.
Well, thank you very much. I'm happy to help. We have to put out the disclaimer that if you do use any of the things that we're talking about, you do so with your own personal liability. But if you think about it, if you ponder what we're talking about, you can see the truth in it. And
Oh, absolutely.
I'm not under the illusion that I have all the answers. Carl's not under the illusion that he has all the answers. Between the two of us, we have a few more than each one of us has individually, but we're still learning. We're still looking for more because we know there's more out there. And don't ever stop looking for more. Ponder what you want to do. Ponder the questions that you're going to be asking. Is that the most precise language that I can use? Are those the right words that I can use? Write them down. There's nothing wrong with having a notepad with a series of questions that you believe are going to be required or valuable within the system, and pick and choose as the situation arises. There's nothing wrong with that. Most people, because of the training, because of the schooling, they don't have the clarity of mind to be able to pull this stuff out of their butt at the moment's notice. So make notes, write stuff down, make sure that your memory doesn't change. And that's why we write things down, is so that the memory of it, the details of it don't change, because we know that what we experience in 6 months later, we're going to view it in a different way. It's going to change. And this is a problem when you're dealing with stuff like court and these legal matters. Make notes. Always make notes. When you're sitting in the evening having your brandy in front of the fire or whatever, thinking about what's going to happen in the next few days, make notes. If you come up with a question, you're thinking about what happened in the last situation, and you go, I should ask that. So write it down. And then when that comes up again, you have the tools. You have them right in front of you. You've already pondered the question. You've already pondered the language, the words you want to use, and they're perfect. They're exactly what you want to say. They can't be misconstrued. They can't be misinterpreted. That changes the game.
Yeah, John, I think when part of the discussion that Mark and I were having yesterday would also involve, because their particular case involves land development. And I don't want to go into too many details, but in essence, they're being forced from their current accommodation because, well, large corporations want to develop the land. And there's quite a large portion of it, especially for the UK. So they're in a position where there is a court case ongoing. I believe this legal matter's been going for, is it 3 years now, Mark?
Oh, goodness.
Now,
I'm sorry, say again, you broke up.
sorry, it was, over 3 years now. And it boils
Okay.
down to, sorry, go on.
No, well, I don't want you to reveal too much, but basically, this process has been going on for quite some time. Mark has managed to acquire some very revealing evidence of collusion and fraud and all sorts on behalf or involving the other side, which is why I think it's gone on for quite longer than it has. But I've also suggested that because there is a court date doesn't mean that you have to sit and wait for the court day to arrive before action actually takes place. You can petition the court at any time. You can go into that court, request a judge in chambers meeting. Certainly if some new evidence has come to light, and certainly if you want to make a new agreement, and you could go straight to the other party, the solicitor at the other side, but I would probably suggest that because of what's been going on, he may not even want to go down that route. So this might have to be a petition to the court and the judge directly in chambers way before the court date ever happens. Is that something that you can support as well, John? That, you know, you don't wait around, because all this stuff goes on in the background between lawyers anyway. They do the deal before they ever get to court. The judge is just there to rubber stamp it in the end. So do the deal, you know.
Yeah.
But if it means you have to sit in front of the judge first, then maybe go that route too.
Yeah, isn't collusion only collusion if it's kept secret? Most definitely. Something to keep in mind, Mark, we've known this for quite a long time, is that what is spoken in the court is irrelevant. The only thing that matters is what's on paper. So if you're going to expose something, if you're going to expose the collusion or anything like that, then you make a counterclaim, you put it in paper, and you file it into the matter. And make sure that it's on paper and it's part of the record, and you have a bulletproof paper trail, so you can prove they got it, you can prove it's there. And so if this does go sideways on you, you have recourse. You can go, look, if you go to a court of appeals, you can say, look, I filed all of this in here. I have evidence of collusion. I have evidence the judge is corrupt and whatever, I don't know the details of the situation. You know them better than I do, most certainly. But make sure you get it on paper and you get it filed into the record. Otherwise, it doesn't mean anything. You can say anything you want in the court as far as evidence goes, and it really doesn't mean anything. It's what's on paper. When they rule, they're ruling on the record. They're not ruling on the oral testimony. They're ruling on what the stenographer has written down. And so keep that in mind. It might make things a little bit easier for you. And also, if you file this paper and it's bulletproof and they have to answer to it, they might just say, well, we don't want to deal with this guy anymore. You too bad, so sad, you lose. It might just go away at that point. I mean, there is that possibility that, you could file the right piece of paper and it just goes away. I think it's unlikely, but it is possible. So
Yeah, I think this development, let's say, I think is so large that they don't want this to go away. They want Mark to go away.
right.
So I think part of my recommendation, if you like, was to because there is an existing contract. It's a more of a lease for the property itself, but the way it was done in the past, there's an operation of law attached to it, and apparently they have quite a lot of power. And of course, they now have some extra evidence too. And Mark's, from what I gather, done a phenomenal job in the last 3 years with trying to deal with this, basically by himself and his, I'll say wife, because I'm not sure, but I think it's his wife, Lise. Partner, okay. So
Writing everything down.
Yeah, everything is just done a phenomenal job. But I'm thinking that it might be good at this point that he should be looking for compensation, potential tort damages, and repayment of expenses that is laid out on the property and on the legal process, and just try and get out of this and find another location for what it is that he wants to do with the property and the land. Which has more to do with assisting ex-servicemen.
I mean, there's the option also, if you want to get out of this, is a conditional acceptance. And, certainly you can have my land. I intended to hold it for the next 40 years and give it to my children. Therefore, there's a significant loss involved in here. So if you want it, my fee is £6 million, or whatever. Make it reasonable. You can't be, off the chart like some of the people, their fee schedule was in the billions of dollars, which is ridiculous. It's not even, you can't justify it. But if it's my intent to hold this property for the next 20 years, then you can pretty much demand what it would be worth 20 years from now. Or not demand it, but, accept their offer with conditions. And that's one of the easiest ways to deal with all of this stuff. If you're willing to let go, if you're willing to actually go through it, then a conditional acceptance is definitely the way to go, because that's entirely honorable. You're not disagreeing with anything. You're putting the onus on them. If they don't want it, then you have the excuse to tell them to bugger off. I made you an offer. You refused the offer. You didn't come back with a counter offer. You have no standing to sue. You have no standing to bring these things to me anymore. So go away. Now, again, this has been going on for a long time. Apparently there's some contractual stuff in there, so that's a little bit more muddied than your typical simple situation. But then, there is that option as well. And, one of the tactics that's used by these guys is to nickel and dime you to death. They just keep forcing you to come back, forcing you to pay fees after fees after fees until you're just broke and you have no more, you can't even afford the taxi fare to get to the court, at which point they win because you didn't show up. And, he didn't show up. Apparently he doesn't care. So they rubber stamp it and you're done. That's one of their tactics.
Quite funny you should mention that, because we was running out of money because they had got hold of 3 solicitors and 2 barristers, which I have the proof at, because it's the people that are involved. They said, one of the solicitors turned around and says, well, there's not a judge in this country which will take this case on, because, the enormity of what I've discovered and the proof of what I hold. Now, let's say so.
Sorry, Mark, say again.
Yeah, you broke up a little bit, but I think I got the idea of what you're talking about. Would it be beneficial to go public? Take your evidence to a reporter and say, look, this is what's going on. This is what I've been involved in with the last 3 years. This is what I found. They're totally screwing me, and they have no right.
I'll stop you there, John. I already went down that route with him yesterday, and he's done that, and apparently that's been stymied as well. People in control at the relevant newspapers have been told not to cover it.
Well, cover it yourself.
So it's no longer being covered.
Cover it yourself.
Yeah.
It wouldn't be. Talk to the people at TPUC. they will help you. And I think it's tpuc.org, the People's United Coalition. And they're in Britain. This is what they do. You might be able to get a tremendous amount of support from those folks.
Yeah, I've already put him in contact with one of the. In fact, I can carry on with that contact process today. But yeah, I've already suggested he goes that route too, because they're really knowledgeable. Obviously, the UK centric, so they have all of the current issues and legislation and so on. And they have all of the support that's already been gathered over the years.
Yeah, but you can also
that was another way to go.
You can also send it out of country. You can send it to reporters in Canada and the States and Australia and India and Scotland. If it in a situation like this, I think personally, my own personal opinion, your best defense is absolute transparency. Make it all totally public, because if the world is watching, things are going to change. And on that note, I think we're going to wrap it up for today. As far as the official show goes, we'll probably keep going for a while with the after show. But thank you, everybody, for being here and for listening to us ramble on for 2 hours. I certainly hope that it was useful. I hope we were interesting. I mean, we did have one YouTube comment going, "It's boring. It's all the same stuff over and over and over again." We have to repeat it because people don't get it. And, some of this stuff, it's so important, it needs to be said 355 times. So y'all have a great day. Oh, go ahead.
Sorry, John. I say, yes, we came across all the information that was repeated and repeated over the last, 25 years between us. So I think 6 weeks worth of shows, no real comparison, to be honest.
Yeah, well, we are sort of given the Coles Notes version because what we got was extreme detail. And it's still out there. I mean, all this information is there. It's all there for the picking. You just got to go dig and look for it. And you have to educate yourself. Nobody's going to do it for you. All we can do is open the door. We can shine a light on it, but you have to go get the information yourself. So do that. Enjoy your week. Anybody who's having issues, try to step back a little bit and realize there is solutions. Sometimes the solutions don't work. Sometimes they do. All we can do is try and keep plugging on, keep educating yourself. So everybody, y'all have a great week, and we'll see you next Sunday.
Yep. Thanks again, John. I appreciate the co-hosting and the producing, and thanks everybody for joining us. And for sure, we'll speak to you again next week. Take care. Have a good week.
Bye, all.